Good afternoon, Chris Gantt-Sorenson and Katie Busbee here to talk about FMLA and ADA. Katie and I, what do you say, Katie? We at least get one call a week about how to navigate these two laws in regards to leave, particularly.
Yes.
And so Katie and I actually just used, we didn't have to go back too far to come up with some pretty tricky situations as scenarios. And thank you, attendees who provided situations. We're addressing those first. So this is an area that I think y'all attendees have been asking for guidance for about 2 years. We did one in March 2023, and so Katie and I decided it was time to do another one. So we're going to do a quick overview, and then we'll get into the scenarios. But as always, we would go ahead and hit next slide. We would encourage you to put your own questions and thoughts as they arise into the chat, and Katie and I'll monitor while the other's talking, and we'll address those and talk to you about those as we go along. Don't forget you get credit if you're SHRM certified and HRCI, and if you're a lawyer, CLE credit. Raven will help with that. Kick it to you, Katie.
Okay. So as Chris was saying, I think FMLA ADA just in general is probably what I get called on the most. And I think leave particularly can implicate a lot of other laws. It can implicate a lot of the company's policies, you know, your PTO policies, short-term, long-term disability. It can implicate other insurance programs. And so, again, we're going to give a little refresher on ADA and refresher on FMLA. And a lot of times employers, I think, have a hard time knowing how to stack leave, what leaves apply, and just making sure they're requesting the right certification, all those types of things. And so we're going to talk through a lot of that today. We also have an ADA checklist tool that we've put at the end of the slide. So all of these slides are emailed out to everyone. So this is a resource that you'll be able to have going forward, that you can, when somebody puts in an accommodation request, whether it's for a duty accommodation or for leave, it's kind of a checklist you can run through to make sure you're handling that correctly. Okay, so again, we'll be focusing on FMLA and ADA today. We're going to do a quick refresher on both of those laws, and then we're going to work through some scenarios, and we're hoping that we will get some interaction from all of you in the chat on things, how you would handle things, or maybe what you think employers should do. Again, there are a lot of areas of interplay between these two laws. So they're similar in some ways, but they can also be very different in some ways. And so I think that too is sometimes hard for employers to make sure they're complying with both. So, you know, they have different employer coverage requirements, different employee eligibility requirements. They both implicate leave, but the lengths of leave may be different. Deals with medical documentation, restricted light duty. Both have fitness or return to work certifications that you may need under both laws. Both deal with benefits while on leave and reinstatement. We can talk through all of that as we kind of move through the refresher. Okay, so FMLA, of course, is a federal law that gives eligible employees at certain organizations unpaid job protected leave for certain qualifying conditions. And I know that many of you know those qualifying conditions, you know, to care for their own serious health condition, to care for a close family member, birth of a child, adoption, placement for foster care, emergencies arising out of military deployment or emergency military leave. I think that was all of them, all of our qualifying reasons. And so there's also eligibility requirements. And I think this is a really hard law for a lot of employers to apply, is because it has very specific provisions, right? There are very specific notices you have to provide, very specific timelines. But then there's also gray areas too, as far as, you know, sometimes it is a little bit of a toss-up whether they're going to qualify, or how to reach out to someone on FMLA, and certain issues that can arise with intermittent FMLA. And that was a couple of questions we received. So there's just enough gray area, I think, to make it difficult. And just as an example, I mean, even in that general description from the statute, words like eligible or certain organizations, job protection, or certain medical conditions, all of that can mean a lot of different things. So I think it can be a very kind of cumbersome law to comply with. Okay, and so for the ADA, for our purposes today, when we're talking about ADA, we are talking about it in the sense that it provides disabled employees with reasonable accommodations so that they can still perform the essential functions of their job. And the way that I think this overlaps a lot of times with FMLA is that one of the universally recognized accommodations under the ADA is a leave of absence from work. And so, a lot of times when you have an employee that is out on FMLA because of their own serious health condition, it's also a lot of times implicating ADA disability, and unpaid leave is an accommodation that has to be explored there. And again, I think with the ADA in evaluating leave, it's difficult for employers to know whether a leave of absence is really needed and how long does the employee actually need, and can we as the employer give that much leave? And we're also going to talk a little bit about light duty and other accommodations as well. Okay, so undue hardship. I know all of you know this as well, that an employer does not have to grant an accommodation if that accommodation causes undue hardship. And so there are certain factors that have to be considered when you're going through that undue hardship analysis. And just from a high level, it basically entails what are the overall resources of the employer and what is the circumstance around that particular employee and their position. So this is a very, this has to be analyzed on a case-by-case basis. So every time you've got an employee requesting an accommodation or needing additional leave, you're going to need to run through this undue hardship analysis. And, in general, larger employers with more financial resources, with more employees, I think have a little bit of a harder time meeting that undue hardship requirement. But again, these are factors that you really have to take into consideration: the nature and the cost of the accommodation, your financial resources, how many people do you employ, how many people do you employ in that person's position. We're talking about, a warehouse worker where you've got 40 other warehouse workers. That's going to be a very different scenario than, say a position where they're the only one, like your CFO or something like that. So again, this is something that really has to be evaluated on a case-by-case basis. Okay, so differences between FMLA and ADA, just from a high level. We've got FMLA stats over on the left and ADA. So, we talked about they have different coverage requirements. So FMLA kicks in when an employer has 50 employees. The ADA, if you have 15 or more employees, you're covered by the ADA. Eligibility as far as the employee goes, on the FMLA side, they have to have worked for 12 months. They had to have worked 1,250 hours in the previous 12 months. And so they have to meet those eligibility requirements. On the ADA side, there's no eligibility requirement that they have to meet as far as like working hours or months. So they're covered from the time employment starts. And actually, they're really covered at the point they apply, because you even have to provide applicants accommodations too. And so they're covered right away. Both laws, I think, come up together. Like I said, when an employee has a serious health condition, it usually also implicates a disability, but the analysis of what those two things are different, and they have different definitions under each law as far as what qualifies as a serious health condition under FMLA, what qualifies as a disability under ADA. Under FMLA, you have to maintain the same level of pay and benefits if you're having to transfer that person to an equivalent position. You've got to make sure that they're not being harmed in any way, even in the duties they're being given, things like that. On the FMLA side, there's not that specific requirement, but you do want to be making that effort, right? There's always that risk of disability discrimination, but there's not that specific requirement under ADA in the same way. There are different rules about how often you can check in with the person when they're out on FMLA as opposed to ADA. FMLA, you can't ask for a status update less than every 30 days if that leave is longer than 30 days, right? I mean, if it's a shorter leave, like, of course, you can check in with them at the time they're supposed to be returning back to work. But for longer periods of leave, you can't be checking in less than every 30 days. And then 1 year if it's intermittent. On the ADA side, you can actually ask for updates every 7 days, unless it's not appropriate for the situation. And so, you know, I would say most of the time, if you've got a doctor's note on the ADA side saying this person's going to be out until this date or whatever it may be, maybe it's not appropriate to keep asking them on updates, right? So you have to be careful there as well. FMLA is a set, you know, it's a set leave period. And in that sense, I think it's a little bit easier sometimes for employers to deal with than ADA. You know, FMLA, you've got, it's 12 weeks or it's, you know, the hourly equivalent if you're doing intermittent. On the ADA side, when leave issues come up, you know, when someone requests, you know, additional leave, there's no set amount of weeks, you know, to be given, then you have to go through that undue hardship analysis. So I think that's sometimes a little more difficult for employers to deal with on that side. So I think those are, from just a high level, some of the differences between the two laws. Next slide. And then, of course, similarities, you know, they both involve unpaid leave. You can't force an employee to take more leave than they need under either law. That's spelled out in FMLA and in ADA guidance. Leave can't be required if the job can be modified or if there's some other position that the employee can perform. They both can implicate job modifications, reduced hours, or alternative positions that the employer has to consider. And then return to work certifications may be required under both for the employee to be able to return to work. The doctor in both situations is going to want to review the job description, be able to tell you about the limitations and when the employee can return. And then, you know, FMLA is job protected leave, have to return that employee to the same or equivalent position. And under the ADA, it's not as strong of a right under the ADA. It's not job protected in the same way, but you do need to do it unless it would cause an undue hardship. So those are some of the similarities between those laws. And I'm moving kind of quickly because I wanted us to be able to get through all. We've got probably the rest of it's more important. So next slide. I think, Chris, this is where you take over.
All right. All right. First of all, we do have a great question. How would you consider reduced hours for an exempt salaried employee? And I know we're going to be covering that a little bit later, but Katie, interested in speaking to that now?
Okay, I'm just reading it. How would you consider reduced hours for an exempt salaried employee? Yeah, Chris, I'll let you answer.
Okay. So we've got an exempt salary employee and they need a reduced hours leave schedule on the basis of either intermittent FMLA or ADA. And presuming they've provided the documentation, we would grant it. If reduced hours would interfere with their ability to do the job or would cause an undue hardship, you know, now combining FMLA analysis and ADA for purposes of just our discussion, those I recommend typically should be done separately just to ensure you're in good shape. But if they're not able to do it or it's an undue hardship, then you can switch them to an alternative position, but know that accommodation has to be considered, even if it's an FMLA leave situation where they're asking for intermittent leave and you're only thinking FMLA leave, then you have to look at if you can't, if they can't do the essential functions of the job or the job's not getting done right, and before you think about sliding them to an alternative leave position, you have to consider whether or not you can accommodate. And when you get into accommodation, undue hardship is defined differently for leave as it is for job modification. That's going to be in your ADA analysis tool. But if we're dealing with a pregnant employee, then it's even harder to establish undue hardship regardless, undue hardship is a case-by-case basis. And while typically ADA, if you say the employee can't do the essential functions of the job, they're not a qualified individual with a disability. If the employee can do the majority of the job and there's an essential function that just needs to be accommodated for a period of time, then the employer probably needs to consider, is it undue hardship to just do that? So, and of course, as always, anything you do, then you've done it, and you might live with it, which it will be something we'll talk about. But that's a great question, and so thank you for asking it. Oh, and in regards to the FLSA with that exempt employee, so we're giving them a reduced hour schedule, or if we're sliding them to an alternative position that's a reduced hours. And this is something that they have asked for and that they need on their medical certification. Then you can take what they earn on, you take what they earn annual or weekly for their salary, and you can divide that by the 40-hour week and then pay them for the amount of hours that they work. And by that, I mean, what is the reduced hour schedule? Let's say we're going from 8 to 6, then that's what you'd be paying them, and you'd pay them the same amount every week. So the FLSA issue is kind of dicey, and I think that's part of what you are asking. All right, so medical documentation for leave under the FMLA and ADA. In the ADA, if you're getting into any medical inquiries, first of all, the ADA is very, very strict about this. You can only do it when there's been an accommodation request, or there is there's a direct threat concern that the employer has about the employee's ability to perform the job safely without injury to the employee or others. And it's about a 2-paragraph definition. Katie and I have a memo that we send out to employers when we're trying to evaluate if direct threat is met. So if you get to that point, please call us and ask about that. That is very hard to prove, very specific requirements, but it exists sometimes. So otherwise, we can't be talking to them about their conditions. So if it's not direct threat, then that means they've got to have come to us and ask for an accommodation. If they come to us and ask for an accommodation, the very first thing that we can do is have them verify from their provider that they have a medical condition and that they need an accommodation. And on that, we're usually saying, you need your provider to tell us whether or not you can do the essential functions of the job, what your restrictions and limitations are. If you can't, how long will that be? When would you be expected to return? Ideally, you want to provide a job description. And I'm a big, big, big fan of job descriptions because they're integral to this analysis for an employer. So then you would attach the job description to this request to the employee's provider. You have the employee take it and they come back with it. And you want the provider, obviously, to have reviewed the job description. I'll tell you, sometimes providers will write down what the accommodation should be. The provider's job is to tell you what the restrictions and limitations are and whether or not this employee can do the job, the essential functions of the job. Yes, no, maybe. It's not their place to tell you what the accommodation should be. They may ask for it, and we don't want to die on that hill every time, depending on the circumstance, but I do alert you to that. In ADA, you can ask the employee who's requested an accommodation to provide a 7-day turnaround. But again, ADA is always case by case, so you want to be flexible depending on the circumstances. Now, FMLA medical certification, you use the certification of serious health condition, certification of medical provider form the Department of Labor has. Always use that. Even if you have another form that's more thorough and you have an employee who is just giving you a hard time about sending anything in, always use the medical certification form. That's what I recommend. In DOL audits, that's what they're looking for. And if an employer is just trying to give the employee a break and let them submit some other form that might have the same information, the DOL will mention it. It's not a record-keeping citation or a violation of any type, but it does. The recommendation is to follow it because it protects the employer and the employee. So just use that form. In those situations, the employee has 15 days to return it if you're handed it to them in person. If you mailed it to them, they've got 18 days. Next slide. All right. Issues with an initial certification that you get for FMLA leave. If it is insufficient, recently I read one that just said intermittent leave where it should have said the type type of leave that this employee needed. And it didn't really indicate the type of leave or how much leave or what would be expected. They gave the employer no parameters to understand what was needed in the context of leave. So if it's insufficient in regards to that, or insufficient in regards to whether the employer can even determine if there's a medical condition that would qualify as a serious health condition, the employer's remedy is to have the employee tell the employee this is an insufficient medical certification and you need to take it back to your provider and get them to complete a new one. And in this situation, we specifically identified the provisions that needed to be answered, by numbers on the form. If the information on the certification is illegible or incomplete, regulation only allows you to have the employee send it back to clarification, or you can do what you need to actually authenticate that the doctor filled it out. And we'll go into what that is. But when we're talking to you about FMLA and we're talking to you about how to deal with this, we're speaking directly from the regulations. So just as insufficient certification is a specific process and regulation, so is clarification and authentication. And clarification and authentication often end up being areas where it's easy to misstep. So we'll talk about that. So an employer cannot ask the employee to go back and obtain more information about restrictions and limitations when the leave request is under FMLA. That's important. So your only remedy there is insufficient certification. You can't say, we need to know more about this or whatever. You just say, this is an insufficient certification. These answers are insufficient in these categories. And then you can always seek second and third opinions depending on what the certification is if you doubt it. So we'll talk about that. Next slide. All right, so clarification, authentication. Clarification means, well, let me back up. Authentication means the healthcare provider looks at the certification and verifies that the information contained on the form was completed and or authorized by the healthcare provider who signed the document. Clarification is contacting the healthcare provider to understand the handwriting on the medical certification or to understand the meaning of a response. So employers may not ask healthcare providers for any additional information or have discussions outside of the limited discussions permitted in the regulations, which we've outlined here. This is why I think employers should avoid verbal communications with a healthcare provider, if it's possible, to get the two answers to these questions, because invariably the healthcare provider is going to share information with the employer that they don't need to know. And if the healthcare provider is documenting their notes as they're required to do on their end, then that's going to show up in the notes, and the employee is able to see their notes. So we don't want anything being written down that sounds like we were asking for more information or given more information than we're allowed to have. So ideally, do it in writing. You might not be able to do it in writing, but ideally do it in writing, and keep the conversation to what we've outlined above. The only person from an employer's office would be HR that should ever do this either. It should never be supervisor or anybody else, never decision maker. HR would be the one that needs to do this. And then if you've done it verbally, make sure it's ideal if you would make sure that the health provider confirms it in writing for you, so you have it in the file in case it's challenged later by the employee. Next slide. All right, doubting certification, we talked about that. If the first certification is at the employee's expense, second certification, if the employer is doubting the medical certification from the employee, is going to be at the employer's expense. And for the second opinion, the employee and employer must agree on the provider, and then the employer has to pay for the employee to travel to and from the provider, have the exam, and reasonable expenses, any out-of-pockets as well. Provisional leave, and if you've got someone who's saying, I can't work because I've got a condition which would prohibit me from working in my job, and their health would be compromised, you can't very well permit them to continue working, right, if they run the risk of injuring themselves. So you might need to grant some leave. And then for second and a third opinions, so a third opinion happens when the employee doesn't like the employer's opinion and they want to get a third opinion. And again, the employee has to be paid for all of that. Next slide. All right, restricted or light duty. Under the ADA, an employer has to offer it if it's a reasonable accommodation that does not create an undue hardship on the employer. I want to say this, an employer is not required to create light duty work. They're just not. You never have to create a job for any employee who wants light duty. What's tough is your workers' compensation carriers are usually asking you to do this because they want to return the employee to work so that what they're paying out goes down. Now, if the comp carrier asks you to do this, typically that can be an exception to what we're talking about under the ADA. But the problem is, once you've done it, then you're going to have to be able to argue pretty tangibly, as a practical matter, why it would be not allowed in a non-workers' comp situation. You still are protected there to have a different rule, but once you start granting it outside of workers' comp, then you're going to have to consider it every time, not just to times you think that it's the right thing to do, unless it's an undue hardship. I'm always most comfortable, obviously, I'm all about prevention, when light duty just isn't even something that we do. If you do offer light duty, then everybody has to get it. Everybody has to get it. You have to be, well, assuming there's no undue hardship, everybody has to get it if anybody gets it. Now, another thing to keep in mind too is that, let's say an employee wants to leave, employee doesn't want to work, but you've looked at the restrictions and you're like, no, we can accommodate this employee. And we can accommodate this employee with some of their duties and it won't be an undue hardship. And you offer that. You don't have to give them the accommodation they've asked for under the ADA. You can offer an alternative accommodation. And so in this situation, you can say, no, we have a light duty position for you that you can come that fits within your restrictions. And then if they don't come, then that can take you down a path that might permit you to separate later down the road, although I'm being very careful here because obviously you would want to get advice and counsel about that. So FMLA, light duty, it covers obviously work absence, but it also allows employees to take intermittent leave. And y'all all understand what that is, and it's a nightmare. But it's leave that's not full leave or that permits them to be absent certain times during their schedule if they can perform their duties. And then, of course, if they can't, we talk about alternative positions. However, these employees are required to schedule their intermittent and advanced leave in a way that does not interfere with business operations. Next slide. Certification or return of fitness to return to work. So my advice is employers need to be asking for this every time an employee goes out due to a disability condition or a work injury. And that they would ask it for everyone. You've got to provide a return to work certification before we'll allow you to come to work. Again, here's where you want the job description. You want the employee to take the job description and you want the provider to read this job description before they give you their opinion. On FMLA, you can only ask for a return to work certification if you check the box on the designation notice. If you do not check that box, you can't ask it. You can't, let's say somebody gets the designation notice and then 12 weeks later they want to come back, you can't ask for it then. The other thing is, if you don't attach the job description to the designation notice and you don't check that box, then the employee gets to tell the provider what their job is, and the provider gets to rely on what the employee tells them, and you can't go back and revisit that. And that's, again, a regulation. So it's up to the employee at that point, and whatever the employee says goes, can't be challenged. Next slide. Benefit continuation on leave. So FMLA, you've got to maintain health coverage at the same level as before the leave. And on other benefits, you would follow your established policy, or to the extent that there are other insurances, your plan documents. Let's say the employee has a portion of their healthcare premium or other premiums that they're supposed to be paying, and they don't pay them. An employer can terminate the health insurance if the employee is more than 30 days late, but the employee must receive a 15-day written notice that their health insurance will be terminated before it is terminated. So typically what we recommend is there is at the outset, written notice to the employee of what your premium is, the due date, and where you send it, how this employee pays it. This is assuming you can't take it out of their PTO or if they're out of PTO. And you have to say in this notice, failure to pay it may result in termination of your policy. And then when we reach a situation where they are behind, we write another letter and we say, I typically like to put the 30-day bit and the 15-day bit in one letter. You are past due this amount. We're going to give you a 30-day grace period to make this right. And after that, your health insurance will be terminated for failure to pay. So there you've met both requirements. If they return under FMLA, you've got to put them back on health insurance, even if they had to get terminated and they are not, they can't have any waiting period. Under the ADA, there's no specific requirements. You can't discriminate, must provide the same benefits as you would to other employees on a non-ADA leave of absence and follow your applicable plan documents. So one thing that is a sleeper issue that I think more and more employers are becoming aware of is that, let's say somebody's been out on FMLA for 12 weeks and the healthcare plan document says that actively at work is what you're required to do to be eligible for health coverage under this plan, which is, as y'all know, 30 or more work hours on average a week. So the exception to that in the plan is typically absence due to health status or health-related factor for 90 days. Now, on day 91, that employee is no longer meeting the eligibility status and they have to be put on COBRA. If the employee gets put on COBRA, they get the notice, but even though they're on COBRA, and this is another error that I see employers make, the employer needs to still continue paying the COBRA premium because this is somebody who's still on the payroll. This person is not terminated. And when I say payroll, I mean, we haven't terminated them yet. And therefore, you have to treat this employee who's out the same way you do current employees, and you keep paying the premium. And of course, they have to pay their portion of the premium. So they go on COBRA. And the reason you have to do that is if you don't do that and the carrier later finds out you carried them past the 91 days, then they may say that this person wasn't actively at work as of such and such day, refund the premiums, and then you're stuck paying dollar for dollar their actual claims. And typically the carrier looks under the rock and does this when the claims are getting high. So the employer is stuck with some big bills. Next slide. All right, job modification or leave. So the EEOC says under the ADA, the guidance for leave said that employers should change the way that things are customarily done. So in the context of leave, this means that ADA leave exceeds all leave that's under other policies, right? So there can't be any maximum leave policies. There's going to always be the requirement that outside of every policy that grants leave or every entitlement for leave, the employer still always has to consider ADA leave and grant it absent undue hardship. So y'all know it's unpaid leave. It doesn't, I see here a lot of employers tie, well, they were out of PTO. This has nothing to do, when we're talking about leave under these two entitlements, has nothing to do with paid or unpaid. Both entitlements are unpaid, and they are entitlements. And so in a situation like this, when somebody has no leave under the remainder of your policies, you still have to consider ADA leave. The process is always the same regardless. And what's reasonable? They have to have a reasonable time to heal. That is fact specific. I would always get them to provide medical documentation, which tells you how long they need to be out on leave. And if the response back is it's indefinite or unknown, then the employer can go ahead and separate in most situations. But if it is a specific time period, then you have to analyze, is it undue hardship under the undue hardship factors that Katie went through and that are for leave listed in the analysis, the ADA analysis tool. One of the things you always have to ask is who's doing the work for the company now and can this continue in this process? And it's kind of tough if it's already been, they've been out for 12 weeks in FMLA and somebody's been handling it. So I think, yes. So in regards to this, if we decide we have to deny leave and we're going to have the discussion, just like we would if we have to deny a job accommodation, we're sitting down with the employee and we're explaining to them why. if we have to deny the leave that's been requested or the accommodation that's been requested, we have to try to see if we can offer other accommodations. So for instance, if an employee needs a leave because they're not able to perform their specific job, maybe under the ADA, you could consider them for some other job for which they are qualified. Under the ADA, you don't have to keep them at the same level of pay, same terms and conditions. So, if they're outside of the FMLA, if we're done with FMLA or they're not eligible, you need to go through that process of, is there something else I can give them that they can do? And all of this interactive process discussion needs to be documented, which means you need to have it with somebody present who's writing down everything you're saying, everything the employee's saying. And then again, as far as pregnancy, it's not a disability. Thanks, Velma. It's not a disability, but conditions that arise due to pregnancy, postpartum, childbirth, nursing issues, those are conditions that would fall under the ADA. All right. Oh, okay.
We got a bunch of questions in the chat and some in our messages. Do we want to go through those now?
Sure. And this was earlier when there was the question about what do we do about reduced schedule leave. I'll just mention this here. This is the DOL 2023 opinion letter. And I think I already covered what you need to do on an intermittent leave situation, but this opinion letter was interesting because it said the employee in this case needed a reduced hours schedule. They had a chronic serious health condition. They couldn't work an 8-hour day. And so they needed intermittent leave. And the Department of Labor said, you're absolutely entitled to this intermittent leave and this reduced hour schedule, and you're entitled to it indefinitely. And if the intermittent leave never expires and they never use all of it, then they can keep, as long as they keep providing the certification for it, they can keep doing that. And at some point, if they run out of the leave, then the employer has to consider, are they entitled to an ADA accommodation? And they may well be if the job was able to be done and the other duties were able to be accommodated on a reduced hour schedule. So things to consider. And as I indicated before you transfer someone to an alternative position on a reduced hours schedule, you have to do the ADA analysis. All right. So questions, Katie?
Yeah, so we got a few in the chat. Says, I had an employee out on her own health condition this past March. She used intermittent leave first, then absorbed her 12 weeks through July 2024. She now has an extended health condition again. We use running FMLA, so I think the rolling 12-month. So how does FMLA kick in now because of eligibility? It would be July 2025, correct? Would she be given FMLA leave as she calls in sick now? So if they use a rolling 12 months, I mean, if she is now requesting FMLA leave, you have to look back the 12 months and see, basically her eligibility would start over. And let's see, would you be given leave as she calls in sick? I feel like there's another question in there I missed.
Yeah, there is. And Katie's right. If she used all of her leave, is this right, Katie? She used it all through July 2024. And then she's been back at work since. Are you reading it that way?
Yeah, that's how I was reading it.
Yeah. So then whenever she meets the 1,250 hours,
that's right.
And the 12-month period, looking back, then yes, she's now eligible again. Katie's right. And
yes, you would, but if she has been out a lot, she might not meet that 1250 requirement. She might. So that's what you would want to look back to make sure she'd have individual eligibility.
And then in regards to would she be given FMLA leave when she calls in sick now? It may or may not be FMLA. But if she is, if it's going to be a qualifying thing under FMLA, then yeah, you get her to go through the medical certification now. She's got to go through that process again. And if it's not a serious health condition, then you have to analyze it under ADA and undue hardship.
Okay, so next, what if you provide the employee with all the necessary forms and they're eligible for FMLA, but you do not receive the certification by the healthcare provider back? And what circumstances should you still grant leave? So yeah, I mean, this happens a lot, right? I mean, so the FMLA regulations say you have to give them 15 days. So at the point that 15 days is coming up and you haven't received it, you should check in with them and say, hey, just following up, still haven't received your medical certification. You know, you got 15 days to return it. Let us know if you need more time. I mean, technically, the regulation says that you can deny the leave if they don't turn it in within 15 days, but it also says you need to work with them if they're having trouble getting it. So I usually tell employers, give them, you know, give them another 7 days, 15 days, but you do have to stay on them about it to make sure that they do get it in. And those communications do need to say, hey, we have to have this. And if we don't have it, we can't designate the leave. And it's, you know, it's going to be under our absence policy at that point, you know, so they need to have that made clear to them as well.
Right. And I would add to that while you work with them, at some point you give them a deadline and then you deny the leave.
That's right. So
and do it all in writing, all this in writing, confirm it all in writing. So the next one is, do you have to invoice them or can you send them an initial letter? Send them an initial letter. When they go out on FMLA with their designation notice, give them a letter that also says, this is what you owe monthly. This is the amount. This is where you send it. And then that language we talked about, if you don't pay timely, your health insurance could be terminated. And I think that's, you know, the specific amounts for all of the things they're supposed to pay and when it's due, to whom it goes. And then the minute that somebody's late, the 30-day grace period letter that says, if you don't pay this within that time, we will terminate your insurance. All right. So I think that's it, right?
We had some more that I think just got sent to us, Chris. It looks like Velma says hers got answered. So I'm gonna go past that one. Somebody says, what if you outsource FMLA tracking to a third party? Yeah, a lot of people do that. Should we still require the employee to complete the DOL form as well to keep on file in-house? And so yeah. I guess you're saying the third party is not using the DOL forms, it sounds like. That's what I'm getting from that. So, I mean, the FMLA regulations doesn't say you have to use our form, but it does say your forms have to say this, 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 and this, and the DOL forms meet that requirement. And so I think that's why we tell you just use the DOL forms, because they're correct. They're kind of universal. You're looking at the same thing every time. So I don't know that you technically have to make them use the DOL form to keep that in-house. To keep it in-house. I don't know if you have any thoughts on that, Chris.
I do, only because of that Department of Labor investigator in the audit recently that said this employer had been so kind to this employee and they just let her turn in a FFD, their fitness of duty form, because this employee she was just not sending anything in. And by the time she sent something in, they just said, oh, we'll just take this. The DOL investigator said, no, you need to use the medical certification of the Department of Labor. Now, if you're outsourcing this, FYI, I would enter into an agreement with this company whereby they provide you with the documentation that you need for your files. A lot of times when you're using one of these vendors and you're no longer using them, they won't give you the documents. And the other thing is you may outsource it, but the company is going to still be liable for violations. So, you know, sometimes I see that my HR folks don't have visibility to how their vendors are handling these issues, and that's a problem and can be a situation where a liability situation sneaks up on you. So I'm going to answer this next one, then I think we should jump to the scenarios, especially since some folks sent some in. So I would not use the Department of Labor medical certification for ADA request. That was the question. Did you mention earlier use the DOL MedCert for ADA requests? Absolutely not. I would have a form that should always be tailored to the employee that says, this employee says they're treating you with you for this condition. They hold this job. Attached is their job description. They've asked for this accommodation. Please complete this form and return it to me. Make sure that you're using a secure like email or fax, because obviously you have an ADA confidentiality responsibility to the employee's medical records. And then the questions are typically, is this employee able to do the essential functions of their job? Yes, no, maybe. What are their restrictions and limitations? If they are not able to perform it, how long do you think how long do they need before they can return to work? And than the doctor's signature to send back. So, all right, I think that's it too, isn't it?
Yeah, there's a
Katie?
few that I'll just answer that were to us, but I think let's roll on to the scenarios.
Yep. Okay, great. Thank you, everybody, for great questions. We always appreciate that. Gives Katie and I something to do other than just our PowerPoint. All right, so next slide. And we'll just run through these real quickly. I already talked about that opinion letter. I already talked about, what you got to do about that. So let's slide on. Workers' comp, you can run this workers' comp interfaces with your FMLA and ADA. And, some of the time, or most of the time, this isn't a problem. But when you have somebody who's been out on workers' comp for a long time, you might say, all right, they've been out on workers' comp for a long time. We're going to go ahead and end their employment. And if you haven't talked to them about FMLA yet, the FMLA regulation specifically says, excuse me, that time of year. The FMLA regulation specifically says, unless the employee agrees for you to apply it retroactively, that you can't. And so then all of a sudden, the person's been out for 8 months and now you're having to do an FMLA period. And then you still have to do the ADA period after the FMLA period expires. In our jurisdiction, so if you're an employee only in our jurisdiction, our Fourth Circuit says the employee does not have to agree as long as it was reasonable for the employer to retroactively apply it. But if you are anywhere else, the jurisdiction's language controls, and if you're audited by the Department of Labor, their regulation controls. They decide what, and they're going to do it on their regulation. They don't care what the courts held. So designate FMLA leave when somebody goes out on workers' comp. And then when that's expired, then do the ADA leave. And we're just doing the documentation. There's a whole process. And with comp, they may also be entitled to short-term disability. So make sure you're thinking broadly. And then again, always be mindful of COBRA. Next slide. So FMLA, pregnancy, and ADA, they all work together with essential functions for accommodations as well as leave. So leave for the length of pregnancy, if that is not an undue hardship as defined by the Pregnancy Worker Fairness Act, which is inability for the duties to get done in the near future, and a much more stringent standard for can't we just, accommodate this undue hardship? Can someone else perform it? And we don't even look at all of the essential functions with pregnancy as long as they can do some of the essential functions. So all of those criteria that are undue hardship markers for employees or employers are substantially loosened and a lot more stringent to enforce for employers. Next slide. All right, scenarios. Here we go. The first two are scenarios that we got from our attendees, so thank you. Employee who has intermittent FMLA for a mental health condition. The certification states that the employee needs an absence of up to 3 times a month, but the employee is missing well over 3 times a month, 8 times a month. And most of the time, the employee is missing for intermittent FMLA on Mondays and Tuesdays following the weekend. The employee tells the employer stress is a trigger, and thinking about coming to work on a weekend can trigger the employee. The employer asks, can we request an updated certification? The answer is yes. Every time that you have a situation where the intermittent leave is not meeting the certification, you can tell the employee this certification does not say you can be absent. It's saying you're absent up to 3 times a month. You've been absent up to 8 times a month. So you send a new certification back to the provider through the employee. And this time you put a letter with it that says employee has been out more than 3 times a month, on average 8 times a month, and is usually out around weekends, missing Monday, Tuesday. The employee reports it's a trigger, stress is a trigger, thinking about coming to work. So giving the doctor the information they need and sending the job description. So yes, absolutely do that and be consistent across the board when that happens. How can we manage this? That is how to manage it. And then hold them, track it, look at how often they are, pull together your facts and hold them accountable to it. And by that, I mean, get a new certification. And what will happen is eventually somebody who's abusing it is going to have a harder time to get the doctor to write it. And it's, you're going to handle it that way. It might take a little bit of time, but if you stay on it and handle it this way, then you eventually will get there. And that's worked for Katie's and my clients in the past. All right, Katie, you take the next scenario.
Okay. So company policy is to closely monitor requests for time off before and after holidays and on Mondays and Fridays to ensure consistent staffing. The company is concerned about what appears to be patterns of abuse for employees who are on FMLA or intermittent FMLA, who may have a legitimate medical need requiring time off for appointments. So it sounds like these people are maybe using their intermittent FMLA on Mondays and Fridays, so around the weekend. How do we handle what appears to be a pattern of abuse? So, I mean, just because they're on intermittent FMLA doesn't mean that they can just, absolutely go out whenever they want to. There's still a requirement that they have to work with their employer while they're taking intermittent FMLA. So to the best of their ability, they have to work around their work schedule. They have to schedule appointments, doctor's appointments around, their work schedule. And so I think you need to have probably a conversation with them. I mean, if they're stacking appointments on Mondays and Fridays and it's really evident that they're just out every Monday and Friday, I think, you probably need to have a conversation with them and remind them that, hey, on intermittent leave, you do still have to work with your employer so that we can also meet our staffing needs. Chris, I don't know if you have any other thoughts on that one.
Nope. I think you got it. All right, scenario 3. Employee requests accommodation for an essential function of his job due to injury. And the employee provides a doctor's note that includes a restriction which would prohibit the employee from performing the essential functions of the job. Here it was the essential functions required the employee to lift 50 pounds. And the doctor provided a note that said this employee cannot lift more than 5 to 10 pounds. The employee had been resisting this particular duty. So this was the only duty that the employee complained about and had been resisting it since the employee was hired. Then the employee contended he suffered a back injury after about 6 months of working there, and this process followed. So the employer looks at the note that came back from the provider, and they say, oh, we can accommodate this employee in a light duty position with all the same terms, same full-time, everything. And so they offer this employee a different position. Well, the employee flips out because the employee didn't want to do that position, and says that he has another disability that prohibits him from doing this position, even though the employer didn't go through the documentation process. He's just resisting this light duty job. In that situation, just saying, the employer could then deny the accommodation request because the employer has given the employee an accommodation. The employee is not choosing to take it, and tell the employee they're expected to report back to work in this position, and if they don't, terminate. In this situation, the employee very quickly came back to the employer and said, I really want to return to my regular job, and if you can't accommodate it, I'll just do the best I can, but I want to come back and I want to do my work. The employer said no, and so the employee went and got another note from his provider 10 days later after the provider wrote the first one and said that the employee can return to the work and he has no restrictions. So what does the employer do?
I'd take them back.
That's right. Take them back.
Yeah, if the doctor says he can do the job, you can't make him go out on leave.
Yep. All right, next one. I can't remember, Katie. Was I getting this one or you?
I think you.
Okay. Teacher's out on pregnancy leave for 9 weeks. That includes, halfway through this fall semester through the end of the semester and the grading period. Teacher's going to return in January at the beginning of the spring semester. The school expects the teacher to review all the submitted work during the fall and assign grades to the students before she returns. Does this violate FMLA, ADA, or pregnancy laws? Can an employer legally require an employee who's out on approved leave to make up their missed work before they return?
Yes. So you can't make, are you asking me, Chris? You want me to answer or you want to go ahead?
Well, I can answer it, but I feel like I'm doing all the talking. I know you know
No,
the answer. You
I
just
can't
had this
answer.
situation for something else.
Yeah, so no, I mean, you can't make an employee work while they're out on leave. The FMLA regulations talk a little bit about how employees can volunteer to do some work, but it needs to be very clear that it is being volunteered and not coerced by the employer. You can make certain little de minimis requests, the regulations say, like, hey, where did you keep this document for the person filling in for you? You know, you can contact them about little small things like that. But no, you can't require them to do work, and you can't require them to make up work. So this comes up a lot too, where there's certain like sales goals or quotas that employees have to meet in a year. Then they go out on FMLA or a long ADA leave, and the employer still wants to hold their feet to that fire in a sense of making up that leave. And or making up that time. And no, you can't do that. I mean, that's going to be disability discrimination, pregnancy discrimination, whatever it's falling under. So you have to be very careful about that.
Yep, that's interference with your FMLA leave as well. So those are statutory violations across the board. Well, Katie, does the answer change if the employee's paid the same regardless of whether their goals are met or they were out on leave?
So no, I mean, answer doesn't change. They're going to need to
Right.
continue to be paid the same. But no, you can't make them make up that time basically and put that burden on them to do that. So no.
Exactly right. All right, next slide. Oh, I think that's me too. Okay, employees' FMLA leave is expired. This is another situation a poor client has. And the employee says, I'm going to return to work, but I can't provide my return to work form right now because my provider is unavailable and I don't know when my provider is going to be back to give me the certification. The employer's health insurance policy covers only those employees who are actively at work. We talked about that's meeting on average 30 or more hours a week, and an exclusion for any employees out on a health-related leave for 90 days. But on day 91, what do we do? Should the benefits be terminated? What do we do in this situation? Do we put her on COBRA? So do we say you got to turn in your form? What should happen in this scenario is we need to give the employee, as Katie said earlier on another FMLA matter, as far as turning in a form, a little bit of time. But we need to put it in writing, and we need to say, employee, thank you. We'll look forward to your return. And we understand you're not able to provide a return to work firm at this time. We're going to give you 10, 15 days. 15 days would match what you're doing at the beginning of FMLA. That'd be fine. So you have until this day to provide the form to us. If you don't, then we'll assume that you're not returning to leave, and we'll go ahead and separate the employment. We're putting the employee on notice. That's important in these letters. And then at that point, and additionally, because we're on day 91, we're going to have to put the employee on COBRA. Employee, you're going to have to go on COBRA because you're no longer eligible, but we'll continue to pay our portion of the premium. You pay your portion. And all of this should be done in writing so you can prove it. Anything you'd add, Katie?
Nope, that's good by me.
All right, let's go to scenario 6. Katie's.
Okay, last one. So production workers expected to go out on maternity leave in June when her baby's born. She's planning to take FMLA. She also has PTO she will use. The company also has a maternity leave policy that basically says you have to take the maternity leave after the birth of the child. The worker also has short-term disability. In March, she's ordered to go on bed rest. So this is approximately 15 weeks before the baby is due. So that means she's going to need to take her FMLA now starting in March, which would also mean that it's going to be exhausted by the time the baby comes. So does the company have to provide her additional leave after that FMLA is exhausted? If so, is her leave protected after that point? So, again, they're going to have to do this analysis under the ADA and PWFA, so Pregnant Workers Fairness Act. Can we provide her more unpaid leave? Does it cause us an undue hardship to do that? And, PWFA says, the regulations say, it's not job protected in the same sense as FMLA, but if you offer as an accommodation unpaid leave, the employer needs to be prepared to restore that person, right? To essentially restore them and hold that job open. That's actually what the PWFA guidance says. And can you make her take that pregnancy leave early? Well, since the policy says it applies after the birth of the child, no, I don't think you can make her take that early. I think you could probably talk to her about it. Hey, when your PTO runs out, if you want your pregnancy leave policy to kick in to continue your payment, it can. But, you know, if she wants to apply for her STD at that point, you know, you can't make her take it, I don't think, because the policy says it applies after birth. And so that's just an example of how different leave policies can come into play. And you need to be reviewing your policies to determine how they're going to stack and have that conversation with the employee.
Yeah. All right. So a question about workers' comp. So if you are running concurrently Family Medical Leave Act and workers' comp, after the leave exhaust under Family Medical Leave Act, can you go ahead and separate, even though the employee, and even though your carrier has indicated the employee is not able to return from the comp entry yet? And there is a South Carolina statute, workers' compensation retaliation, and it carries punitive damages and pretty easy to prove. And there's only 7 instances where an employer can terminate an employee after they filed comp, and unless there's one of those is met, sorry y'all, that time of year, and these are pretty egregious things, by the way, then no, I wouldn't recommend it. That statute expires 1 year after the claim is put in. Excuse me. Katie and I recently had a case where Katie challenged me on this, and I want Katie to speak to that as far as the 1 year statute of limitations, Katie. But just because FMLA leave is expired, you have to go through the comp analysis separately before you decide to release them. And you need to be following, obviously, what you were learning from your comp carrier. So, Katie, what about that 1 year statute?
Yeah, that 1 year statute of limitations for workers' comp starts running at the time the termination takes place, or the alleged retaliatory act. And so it's not necessarily that you could wait a year and run that statute of limitations from the time the person files for workers' comp. It actually starts running at the point that they are terminated or retaliated against. So.
And so you're doing the ADA analysis after FMLA on this, and that's back to case-by-case basis. And I think a lot of that depends on what your workers' comp carrier is deciding. Would you agree, Katie?
Yes.
Yeah. All right. I don't think I see any more questions, and we are certainly out of time. So excellent questions. Thanks for those who submitted scenarios. This was a lot of fun for us. And so make sure you're joining us on April 24. I'm going to have Jake Modla. He works, he's an attorney, been an attorney for a long time. Right now, he's a plaintiff's employment attorney at Kramer Babb. And if any of y'all have dealt with Kramer Babb, you know they're a notorious plaintiff's employment attorney firm in the state. But Jake was also on our side of the fence. You know, he's a defense lawyer in employment law for years. He's going to come and give examples of what he typically sees employers doing wrong in his litigation matters. So it's going to be very informative for us all. And then we're having our legislative update June 26th. Joseph and Katie will come back and talk more about all the great stuff they shared with us in January. And we got to figure out what we're doing in May, and we're taking a break in July, and hope you will too. Thank you, everybody. We'll see you next month.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.